Okay, we'll go ahead and start this webinar. Thank you for joining.
All right. Hello, everyone. Welcome. Thank you for joining wherever you're joining from. Thank you for taking the time to do that. My name is Lisa Frank. I'm a senior specialist in the Housing Accountability Unit. My co-host today is Brandon Young, also a specialist. And this webinar is all about public review of HCD's draft Assembly Bill or AB 2011 guidelines. You might be wondering if you're recording, if you didn't catch that, the answer is yes. Once the video is available, it will be posted to our webpage. Brandon is going to leave some links in the chat here. And if you take a look at those, you'll find one that says webinars and workshops. This is where the recording will get posted once we're able to do that. So if you're checking back and you're seeing or you're not seeing it, you can email us at the project email address, which will also be noted in the chat. And that is AB 2011 guidelines at hcd.ca.gov. And we can take a look at the status. So first, I'm going to spend a few minutes on this slide just talking about today's webinar. Because if you signed up and you're here and you made it, again, thank you. You might not be totally sure what you signed up for. So I just want to set some expectations, provide a little bit more clarity about that before we really get into things. So HCD is doing this webinar because we have prepared a first round draft of AB 2011 guidelines. So we took a stab at it. This is just a start, right? And now what we're really looking for is your collective review and feedback on these guidelines so that we can go back with your feedback in hand and see how we can make them better, more useful, so that this can become a really helpful resource when it comes to actual implementation of this law. We can't clarify something if we're not aware that it's an issue, right? So what are you seeing? What can you help to put on our radar that is within the scope of the guidelines? And we'll talk more about that. With that big picture goal in mind, what does this webinar include? So first, it includes a high-level overview and orientation of the draft guidelines. In addition, and really above all else, it includes an opportunity for you to provide verbal public comments to HCD regarding the draft guidelines. And the importance of this is reflected in the fact that we are going to reserve most of our available time today for that purpose. And whether all that time gets used or not, we'll have to see. It just depends on who wants to provide a comment. But we're wanting to create a space for that, and so that's what we're doing. So really what we're asking you to do and to think about is, what do you want HCD to hear about implementation of AB 2011? How the law is working in practice in the real world, such that HCD can then go back, think about the comments and the issues, evaluate and consider potential changes or updates in the next version. With that said, what does this webinar not include? Because we do have to establish some boundaries to help keep things running as smoothly as possible. So this is not going to be a comprehensive training or deep dive into AB 2011. Brandon is going to cover a few slides with an overview of the main components of the law, but that's really the extent of it for today's session. We definitely encourage you to read the guidelines. That's a great way to familiarize yourself in more detail. And in addition, for those that might be just starting to learn about AB 2011, you might be interested in taking a look at HCD's AB 2011 Housing Law Fact Sheet, which is also posted in the chat that Brandon, or linked in the chat that Brandon posted. But, we simply can't cover everything today, and this is just not designed as a training. In addition, this is not an opportunity to get on-the-spot technical assistance from HCD on individual AB 2011 issues. But there is good news. For that, you can use our Housing Accountability Unit portal. The link is shown on the screen here, but Brandon has also posted it in the chat. Some of you might already be familiar with this, but if you're not, you can use this portal to submit a request for technical assistance. And when you do that, an analyst will be assigned and they can properly intake and evaluate the request, the specific circumstances, using a process that we have in place exactly for that purpose. Lastly, along the same lines, this is not an extended, in-depth Q&A session type of opportunity. You will notice that there is a Q&A function, and so that's there. So the only thing with that is please don't use it for providing public comment or asking really detailed or extensive nuanced questions. It's really best suited for more minor questions that lend themselves to brief answers. And we will do our best to take a look at that Q&A intermittently throughout the webinar. If there are things that we're able to easily address today, we're going to aim to do that. We want to be helpful. Realistically, though, just please bear with us. It's just two of us hosts here today. It can be hard to tend to that while we're presenting. And again, the primary purpose for today is for you to provide your public comments. If we do answer a question in there, you will see that question and answer appear in the Q&A box. And again, with this, there is good news. Any questions that we cannot answer today for one reason or another, those will be available to us after the webinar. So we can and we will go ahead and take a look at the questions that came through and provide any necessary follow-ups. So with that, thanks for hearing me out. Hopefully that sets the table for what to expect today, and we will continue. In terms of the public review process that we're doing here, this is just kind of a quick recap. So HCD posted the draft guidelines on May 5th, and today's webinar takes us to about midway through that 30-day period, where again, we're going to collect your verbal public comments, and we will continue to collect comments on the draft document through June 4th. So whether you've already read through everything front to back, or you're opening it for the first time, there is still opportunity to review and share. Today is just one opportunity for that. If it turns out that we will be making substantive changes to this initial draft, there may be a secondary public review period, but we really can't make that determination until we complete this first round process. And again, the email for the project is noted on the slide here and in the chat, AB 2011 guidelines at hcd.ca.gov. So again, this is your opportunity to help shape the guidelines. We're really relying on that feedback to help make these as useful as can be. We are going to compile and review all of the comments that we received through this process and review them. And then a summary of those comments, as well as our responses, indicating how or if they've been incorporated or not, will also be published with the updated guidelines. So why guidelines? Why are we doing guidelines, and who and what are they for? When the legislature passed AB 2011 in 2022, taking effect in July of 2023, they granted HCD with the authority to create guidelines. And with this, HCD was given permission to issue guidelines that, quote, supplement or clarify the terms, references, or standards set forth in the chapter. And here in orange, in the orange box, is the specific language in the statute where that authority is established. Now, although the guidelines and this webinar are for anybody that's interested, the main users ultimately are those that are implementing AB 2011. So that would primarily include local government staff, perhaps consultants that they might be working with, as well as housing developers and their teams who are proposing or seeking to propose AB 2011 developments. And of course, we know there's others out there who are interested and will want to refer to these as well, and that's great. Please do that. And the intention, again, with these guidelines is to provide clarifications that help address some of the more common areas of confusion in the statute, the things that are making it harder to implement and harder to use. Because ultimately, what that probably means is that those housing developments are taking longer to move through the review process because of these sticking points that come up. And ultimately, that has the effect of undermining the intent to streamline these projects and facilitate housing for compliant developments. So all in all, the guidelines are envisioned to support more effective and consistent implementation of the statute throughout the state. In terms of outcomes, remember, this law has not been around for very long. Again, it only took effect in July of 2023. We do have some data. The annual progress reports, or APRs, from 2023 and 2024 tell us that based on the reporting from local governments through the APR that gets submitted to HCD, approximately 4,000 units worth of AB 2011 housing have been submitted to various jurisdictions for review. Within that, nearly 2,000 units have been issued planning approvals or entitlements. Now, you can form your own opinion about whether that number is high or low or somewhere in between, and we'll see what the 2025 APRs show. But the point here is that HCD's hope is that the guidelines can help support an increase in those numbers, which ultimately means more housing to help address the state's undersupply of affordable homes. So what are guidelines in the first place? Because we don't want to take for granted that everyone knows exactly what guidelines really are. So how should you think about how to use them and what role they play? Guidelines are somewhat unique because they have actual regulatory authority. And that ties back to the previous slide and the language in the government code itself that granted HCD with this guidelines authority. That said, it's very important to keep in mind that guidelines do not create new statutory provisions. Remember, HCD is not the legislature. So these supplement or clarify the law as it is written. So this can include things like rephrasing, elaborating, reorganizing, supplemental, kind of explanatory tables, bringing more meaning and hopefully clarity to the words on the page. They serve as a companion document in that sense. And in terms of clarifications, we're talking about a range when it comes to the significance. Some are going to be very minor in nature, and it's more about maybe making the information easier to digest, whereas others are more significant, or we're doing more of the elaborating or supplementing, to use the words of the statute. Here's a really simple example to illustrate a version of what I'm talking about. This is an excerpt from the guidelines. It says that the local government shall ensure that any development approved pursuant to the Act and these guidelines satisfies the requirements concerning the demolition and replacement of housing units specified in, and then the relevant government code section after that. So in the guidelines, this is all going to look the same black text, but just for illustration purposes, the red text highlights where the language has been slightly rephrased to make it maybe a little bit more approachable or straightforward, making it more obvious what this is referring to. So just an example. And then something else to be aware of, at the end of each section of the guidelines, you will find a little blurb like the one on the screen here that notes the authority and references cited in the corresponding section of the document so that you can be aware of what parts of the statute these sections are relying on. And with that, I will pass it over to Brandon to provide us with some additional background on AB 2011.
Thank you for that, Lisa. Just to provide a little bit of a refresher, I'm going to discuss a high-level kind of summary of what AB 2011 does. Next slide, please. So AB 2011 took effect on July 1st, 2023, after being signed into law in 2022. So far, there have been 2 amendment bills that have made further changes to the original version, including AB 2243 and AB 893. There is another bill currently pending in the legislature right now. AB 2011 does 2 main things. First, it established that housing is an allowable use on eligible sites in defined urban areas statewide for projects that meet certain characteristics. Second, it creates a new streamlined ministerial review pathway for those eligible housing developments. The bill is one of many in recent years passed by the legislature to help facilitate housing production, particularly in urban infill locations. In the author's own words, the goal is to promote affordable housing development with a requirement to create high-road jobs. Next slide, please. This is a snapshot of some key pieces of the law. Zones for housing under AB 2011 include sites where zoning principally allows for office, retail, or parking uses. And of course, there are some caveats associated with that. For affordability, a development must qualify as either 100% affordable or mixed income. When it comes to development standards, there are a slew of requirements that may apply. For instance, density requirements, as well as applicable objective development standards. There's also a variation on those depending on whether the project is 100% affordable or mixed income. And again, for process, the statute establishes 2 main types of timeframes that apply to the local government's review of the AB 2011 application. First, there is the review timeframe for determining project consistency with AB 2011, including timeframes for resubmitted applications that were determined to be inconsistent. Secondly, once a project is determined to be consistent, there's a timeframe for actually issuing the approval. On the local government implementation side, the statute allows local governments to swap out parcels. In other words, you can exempt a parcel but only if it meets certain requirements, namely that there is no net loss in residential capacity compared to what AB 2011 would have allowed. Lastly, there are a host of labor-related standards laid out in the law. These are included in the guidelines. Note, however, that HCD does not have purview over labor standards. Next slide, please. There are many site eligibility requirements. This table is not an exhaustive list, but gives a rundown of some of those requirements. Some of these only apply to mixed income projects. The list includes, but is not limited to, zoning, various environmental conditions, for example, limitations on farmland, wetlands, earthquake zones, etc. A requirement to be surrounded by urban uses and distance from oil and gas extraction facilities. For mixed income projects, things like commercial corridor frontage, maximum acreage, and preclusions related to tenant protections and removal of certain types of rent-restricted housing and demolition of historic structures comes into play. So now I'll pass it over back to Lisa to discuss the draft AB 2011 guidelines.
Great, thank you, Brandon. So yeah, now we're going to get into the actual draft guidelines, and you can think of this as kind of an orientation or preview to what you're going to find. If you'd like, you can follow along by opening up the draft guidelines document. The link on the screen here is pretty long, so probably best to just refer to the link that Brandon has put into the chat. And we'll pause for a moment just to give folks a little time to get situated with that. All right, so hopefully you're able to do that. Here are the draft guidelines kind of at a glance. Overall, it follows a similar structure as the statute itself. There are separate sections for the 100% affordable developments and for the mixed income developments, just like the statute. We thought that made a lot of sense. Because some of the requirements are the exact same for both project types, we try to reduce some of that redundancy by creating, for example, a single section regarding process that applies to all AB 2011 developments. And we did the same for the post-approval requirements instead of kind of duplicating that information. So now in the slides that follow, I'm going to highlight a little bit more about many of these sections. And again, I'll note some sample clarifications, but this is not going to cover everything by any means. So Article 1 sets the table for what the guidelines are, what they do, how they apply. One of the, or most of all, includes definitions, and the majority of these are from the statute itself. In terms of sample clarifications, there's actually quite a few already in the statute, so those are carried over into the guidelines, but we did add some for terms that are used in the guidelines and statute, but that are not included as actual definitions in the statutory language. So if you're following along, you can find the definitions in section 102. And for example, we've added a definition for application. That might sound a little silly, but you'd be surprised. Section 102V includes a definition for ministerial review process, or streamlined ministerial review process, as these terms are used interchangeably. Section 102AA has a definition for objective zoning, subdivision, design, planning standards. And section 102II adds a site or project site definition to reflect a more recent provision added to the statute relating to what a site is considered. So, of course, a very foundational aspect of an AB 2011 application. Article 2 is regarding 100% affordable developments. The sections here cover site eligibility, affordability requirements, requirements that apply to the development, including density and objective standards, as well as kind of a catch-all for additional conditions of development. So for example, this would include the features that are required when proposing to site AB 2011 housing within 500 feet of a freeway, or the condition of approval requiring a phase 1 environmental assessment, replacement housing, things like that. Some sample clarifications. In the affordability requirements, if you go to section 201C1, we clarify that the local government cannot require affordable units above the lower income level that would otherwise be required by a local inclusionary housing requirement. When it comes to, while the statute addresses local affordable housing requirements or inclusionary housing requirements for mixed income developments, it's silent when it comes to the 100% affordable development. So this clarifies that potential sticking point so that it doesn't become a barrier to pursuing the 100% lower income option under 2011. Another clarification is regarding maximum density. This is in section 202B1B. The statute very clearly establishes a minimum, but then again, it is silent on maximums. So in light of that, this clarifies that there is no specific maximum numerical density, though a project would still be subject to other applicable objective development standards. Article 3 is regarding mixed income developments. So similar to the previous slide, you're going to find site eligibility, affordability requirements applicable to the development project, and those additional conditions of development. So in the mixed income section, for example, you'll also see the commercial tenant notification procedures that apply to this project type, as well as the ones that I noted on the previous slide. In terms of sample clarifications, in section 300A10, the guidelines clarify that for purposes of the neighborhood plan area site eligibility requirement, that the provision requiring the plan area to permit multifamily housing includes principally permitted or conditionally permitted. This also applies to section 200A6 since this criteria is the same for both project types. Section 301A6 in the guidelines include elaboration on how to do the combined affordability calculation when there's a local affordable housing requirement in place and where that has to be applied on top of and together with the AB 2011 affordability requirements. And then section 302E2 through 4 includes various minor clarifications related to AB 2011 setback requirements. Article 4 is all about the streamlined ministerial review process. And this includes sections for applications and fees and local government processing. Some sample clarifications in this article are found in section 401B, which addresses the AB 2011 consistency review. So pretty big topic. And in that section, the guidelines clarify a few points. First, the application submittal starts the review of both the Permit Streamlining Act or PSA application completeness review and the AB 2011 specific project consistency review determination. Second, that the local government must complete the AB 2011 consistency determination in the timeframes specified in the statute, even if the application is found to be incomplete under the Permit Streamlining Act. And with that, an incomplete application on its own is not automatically an inconsistent project application, even though, of course, it could turn out that both are true. So that's paraphrasing. And then lastly, the guidelines also clarify that while the Housing Accountability Act, or HAA, applies to AB 2011 developments as specified directly in the statute, that the consistency review timeframes of the HAA do not apply on top of AB 2011. Okay, and then here we have Article 5. Article 5 is regarding the post-approval requirements. So the things that happen after the 2011 entitlement application is approved. And this includes things like project approval expiration, subsequent permits, which are the things like building permits, construction-related permits, and project modifications initiated by the applicant. For sample clarifications in Article 5, bear with me, this one's a little on the clunky side in the weeds, but Section 501A is regarding local government issuance of subsequent permits for an approved AB 2011 development, or the subsequent permit is consistent with the approved development. And it references back to Section 102KK, which is the definition of subsequent permit. Putting these two together, The guidelines clarify that subsequent permits include permits that meet the definition of post-entitlement phase permit under Government Code Section 65913.3, which includes requirements regarding the local government's review of the universe of post-approval permits that come after the planning entitlement. And then in the actual statute, you'll find that there's a lot of cross-referencing going on when it comes to the subsequent permit requirements. In particular, you'll see references to various portions of Government Code Section 65913.4, which is the streamlined ministerial, this should say approval process, or SMAP as we call it. Most often this is known by its original bill number, SB 35. We have added the actual language from those reference sections into the guidelines so that it's in one place, therefore reducing the need to refer over to another statute to find out what applies to the project. And then we're coming to the end here. Article 6 pertains to the end of the walkthrough, I should say. Article 6 pertains to the parcel exemption provisions in AB 2011 that Brandon mentioned. And this includes the 100% affordable development sites and mixed income development sites. So here in sections 600B and 601B, the guidelines do a bit of rephrasing to enhance clarity around the required findings that are necessary when a local government wants to exempt parcels from AB 2011. And in section 600B1B, there is some clarification around the capacity calculation for 100% affordable development sites for purposes of complying with the no net loss provision regarding residential capacity when a local government is again seeking to exempt a parcel or parcels. Okay, so with that, we are going to now move into the public comment portion of the webinar. And just so you know what comes after that, once we complete the public comments, we will have one final wrap-up slide, and then we'll be all done for today. So as we get started here, recall from the beginning of the presentation, the types of comments and feedback that we're really hoping to get that are within our scope here. So remember the big picture. What would you love to see clarified about AB 2011 in the guidelines? Not what would you want to see changed about AB 2011, or what do you not like about the statute? So what's your clarification kind of wish list, particularly those things that are likely to come up more regularly as opposed to more one-off unique situations? Now, in addition, your feedback can also take the form of you identifying a clarification that you think is wrong, that you think we just missed something, or we have clarified something incorrectly, or perhaps made a mistake. It could be something you heard mentioned today, or if you've already reviewed the guidelines and noticed something, it could be that too. Just please let us know. You might be surprised to know that we are not perfect. We don't have all the answers. We're open to getting more information and revisiting accordingly. So that's really what this is for. You can also offer up your own clarifications, and even better, if you're able to point to where in the guidelines you're looking when you do that. The more specific you can be, the better. You can think about the way the document is organized, tables that would be helpful, that sort of thing is also fair game. And so with everything you've just heard in mind, when you go to give a comment, just take a moment to please consider if it falls within the scope that we've laid out. And then again, some topic areas you might want to consider, but are not limited to, are the core components of the law, things like the site eligibility, affordability requirements, provisions related to applicable objective standards, review process, definitions, parcel exemptions, or maybe something else altogether. And I'm about to turn it over to Brandon, who's going to get us started. But one more thing is to just remember, when we say public comment, what we mean is we'll call on you, you'll provide the comment. We're going to listen. We are recording this again, and we're going to take it into consideration and review and evaluate following this webinar. If it makes sense to do so, I may add brief commentary after completion of the comment, but for the most part, we're just going to continue on through the queue to make sure that we can give people who want to speak a turn to do so. Okay, so with that, I'm going to pass it over to Brandon, who will walk us through a little bit more about how we're going to run the public comment here.
Thanks, Lisa. So how we're gonna run this is kind of similar to maybe like a public commission meeting if you've ever attended one over Zoom. So if you wish to provide verbal public comment, you can go ahead and raise your digital Zoom hand. It should be under the react button if you see it. And you will be afforded 2 minutes to provide your comment. It'll be recorded, so we'll make sure that we document it. Once your time is up and your comment's been provided, we'll transition to the next person who should be queued up in order. So now is the time, if you care to provide a verbal public comment, that you could raise your digital hand. So it looks like we have Nello Manciati. You should be able to unmute Nello.
Hello.
Hi there, we can hear you.
Yes, hi. So my question is that it seems like with this measure, it basically, in order to apply for the ability to build low income housing, the wage for what we pay our contractors basically goes up. Is this correct or is this incorrect?
So it sounds like that's your comment. I'll be able to provide hopefully helpful information. It sounds like you're referencing the labor standards in AB 2011. Those are requirements that are provided in statute, and those requirements will not be changing because the guidelines are clarifying in nature. The guidelines document that HCD is working on does not revise requirements in statute. All right. Well, we have some more time allotted for any public comments should any of our attendees wish to provide verbal public comment. As was previously mentioned, we also have ample other avenues to provide your comment or input. So feel free to check out our email address. We're taking comments until June 4th. Looks like we have another attendee, Ugochi. You are next up, so you should be able to unmute now.
Hi, thank you so much for this presentation. My comment is related to, I'm not sure if the guidelines will touch upon this, but the intersection with the affirmatively furthering fair housing duty under state law. So if you could talk about that, please. Thank you.
Brandon, do you mind if I just chime in for a moment here? So this is Lisa. Thank you for the question and comment. I just want to remind folks, this is really designed for providing public comment. So even questions that you have, we're going to have to accept those as public comment. If we have a little bit more time at the end to elaborate, we'll do that. I'll just say regarding the topic of affirmatively furthering for housing, you will find in the section regarding the parcel exemptions, a portion of that applies to that portion of the statute, some information regarding how that intersects with affirmatively furthering for housing and the findings that the local government would need to make if proposing to essentially exchange or swap out exempt parcels as provided for through AB 2011. So thank you for the comment. We'll document it accordingly. And again, just a reminder, we're limited in being able to answer all questions on the spot today.
All right, our next commenter is Anthony Carroll. Anthony, you should be able to unmute.
Hi there. Anthony Carroll, speaking on behalf of the North Coast States Carpenters Union. My comment is that if possible, while it was just clarified that HCD cannot change anything in the statute regarding the labor standards portion of AB 2011, I think these guidelines are a great opportunity for HCD to clarify that the healthcare expenditures outlined in the labor standards, specifically in section 701, do not just refer to additional monies paid on the check, as they would with regular prevailing wage jobs, and that it was the intent of the sponsor and authors that those healthcare expenditures go towards healthcare payments specifically. So I think that that is an important clarification that could be made with regard to the labor standards. Thank you.
Thank you for your comment. So we do have some more time if any of our attendees have any other public comments they wish for HCD to take into consideration during our public comment period.
Brandon, I did see a question come in through the Q&A that I'm going to address verbally. Someone asked to clarify if comments can be submitted through the Q&A. We did note that that is really not the best place to provide the public comments, that the best place is either verbally here now or through the AB 2011 guidelines email. That said, it's there and we get it. And if you, feel strongly about making a note there, go ahead and do that. We're still going to, again, collect everything that comes through during this webinar, whether it was verbal or written. So I hope that helps. Again, just the preferences, provide the verbal public comment and then email us. But, we're not going to be overly strict about it if you want to make a note in the Q&A as well.
All right, so we have no one else queuing up to provide comment. I'll give it a bit longer in case there are any attendees who want to take the opportunity to provide verbal public comment.
While we're waiting, Brandon, I'll try to address some quick questions that I'm seeing here. So bear with me. Somebody asked about why can't HCD have a say on the labor standards portion of AB 2011? So just to kind of recap that, and I know it's come up a couple of times, you will find a whole section in the guidelines with the labor-related provisions of the statute because it's part of that government code section. We kind of added that caveat because ultimately HCD does not have purview over labor requirements and labor standards. So it's not our expertise either. We're really looking at the review of the housing development project. So I hope that clarifies a little bit. I don't know if that fully satisfies the question, but I just wanted to address that because I know there's a lot of interest in that as well. Let me see if there's anything else. It looks like actually we have a hand raised, so I'll pause there and pass it to you, Brandon.
Okay, Yvette Romero, you should be able to unmute at this point.
Hello, everybody. Thank you for this opportunity, and thank you for trying to clarify more of this AB 2011, specifically the site-specific sections, like eligibility around commercial corridors, maybe defining or clarifying what the adjacency portion means of that commercial corridors, and the objective standards that can make the project feasible. Our biggest concern is making sure objective standards stay objective with our local jurisdiction, and that they don't interpret the law in a way that brings subjective review back into what is supposed to be a ministerial process. That's kind of a barrier that we're coming up to right now. And AB 2011, I think could be used or is being used for a great housing production tool. But consistency with the local jurisdiction, I think, needs to be clarified more and reinforced more by HCD. Thank you very much.
Thank you for your comment. It has been noted. I see that someone has submitted a comment in the chat. I'll make sure to record that for our purposes of recording public comment. We have another commenter, Reynard, who should now be able to unmute. Reynard,
I'm sorry, I didn't press allow. Can you hear me now?
yeah, we can hear you.
Perfect. Reynard, City of San Diego. This question is regarding Section 401, local government processing. And I did go through these guidelines really quickly, so I might be missing some information. The city actually has regulations for environmentally sensitive lands that's not covered under other provisions of 2011. So under the objective standards criteria, our provisions essentially require no impact to those specific lands or maintaining a very specific distance from those resources. If a project doesn't comply with that, is that a consideration under Section 401 to deny it because it doesn't comply with the objective standards? Under Section B1 on page 41, there's a little blurb about a standard that requires another discretionary permit shall not constitute an objective standard. So I'm wondering maybe if that could be clarified, or maybe if there's already an interpretation that in our situation that I just described, whether that constitutes an objective standard that would disqualify our project from 2011. And I could clarify if needed. I know I went through that kind of fast. How you doing, Brandon?
Thank you for your comment. It's noted as we're kind of collecting verbal comment, and unfortunately, we're not necessarily equipped to provide really technical responses, but it's certainly noted and something we'll take into consideration as we develop the guidelines further.
Appreciate it. Thank you.
And Reynard, and I'll just add, if you have the opportunity and you want to provide a follow-up on that to the email that kind of lays out more about the standard that you're looking at, that would be helpful too, and we can take a look and consider how we might clarify that in the guidelines. Great.
Yeah,
Thank
gotcha.
you.
Thanks, Lisa.
Thanks.
All right. Well, seeing as though there are no more raised hands, I think we can move on from our public comment period.
Brandon, sorry to throw us off. Just because we do have a little bit more time, I'm going to answer a couple more questions. Oh, did I just see a hand? Maybe not. I'll quickly address a couple more questions that I'm seeing in the chat / Q&A. Somebody asked, is there an option for developers to pay a fine or fee, I guess, and not build the affordable housing? So under AB 2011, the affordable housing requirements are for units to be provided in the development project. So hopefully that helps answer that question. Give me a moment. Let me just see if there's anything else. Well, we have access to this PowerPoint. So this answer isn't as straightforward as you might think. Again, this is being recorded. If people are interested in the actual PowerPoint slides, just know that when we make those available to the public, we do have to be mindful of ADA accessibility and remediation. So if you're looking for that, I think the best thing to do for now is to send us an email at the project email address, and we'll see what we can accommodate there, because we understand that there's interest in that. And let me see if there's anything else. I'll quickly address a question I see about Section 202B1B regarding 100% affordable development projects. This is probably in response to something I noted in the slide. It says, does this mean that 100% affordable projects are exempt from local zoning requirements and have unlimited density? So what we're saying in the guidelines, what we're clarifying in the guidelines based on what the statutory language provides, is that there is a minimum density applicable to the 100% affordable projects, and there is no specific maximum numerical density. So in that sense, yes. However, we also noted, and the guidelines also note, that there still are the development standards that are going to apply to that project that will ultimately help inform, the project's building envelope. Okay, I think that's okay. Let me just see if there's anything else I can quickly address here. Somebody mentioned clarification on the requirement for public improvements. Thank you for providing that. And for the person that sent that, feel free also to email us, and just if there's anything you want to elaborate on, to perhaps give an example or something along those lines, feel free to do that too. Okay, and then we also got a comment regarding potential contradiction in terms of the site and the maximum acreage. So we'll take a look at that as well. Okay, do we have any hands raised, Brandon? If not, I think.
No more hands raised.
Okay, all right, all right, so thank you so much, everybody, for your participation. And with that, we are going to turn back to our slides here. So again, the public comment period is going to continue through June 4th. So having now attended this webinar, hopefully you've gotten a little bit more familiar with what the guidelines are doing. Again, we couldn't cover everything, so you'll have to, if you really want to dig in, please take a look at the guidelines. It's a great read, and we're really looking forward to your feedback. And again, you can email us at ab2011guidelines@hcd.ca.gov. Again, look out for a possible second 15-day public review period. Of course, if we're making public major changes, we want those to go out for review. Again, once the draft is updated, HCD will publish a summary of the comments received, and again, the responses that indicate how or if how those comments have been addressed or incorporated or not, if that's not the case. And with that, thank you again so much for your time and attention to this. And we look forward to hearing more from y'all.
Thank you for attending the webinar. This webinar has now concluded.